this concept feels different. Not ownership, but rights over someone else's land, like using another person's property legally?
Yes, exactly. This is easements. You don't own the land, but you have a legal right to use it in a specific way. And for valuation, this is extremely important. 1. Definition: understanding dominant and servient land.
Dominant, servient. Sounds technical. What does it mean?
Let's simplify. Dominant heritage, benefited land. Land that enjoys the right. Servient heritage, burdened land. Land that carries the burden. So one land benefits and the other suffers? Not suffers, but legally obligated. Example: your plot has no road access. You get right-of-way through neighbor's land. Your land equals dominant. Neighbor's land equals servient. 2. Key characteristics, core legal conditions. What makes a valid easement? 2 distinct properties must exist. Right must be for beneficial enjoyment. Owners must be different persons. Right must be capable of forming legal subject. So I cannot have easement on my own land? Correct. Easement always involves 2 separate ownerships. 3. Nature of easement, not ownership. Does easement mean partial ownership? No. It is a personal right. It does not create ownership interest. So only usage right? Yes. Right to do something or prevent something. Example: right of way. Right to light and air. Right to drainage. 4. Creation of easements, how rights arise. How do these rights come into existence? First, by grant, through legal deed or agreement. Second, by custom, long-standing local practice. Third, by prescription, continuous use for 20 years. So long use becomes legal right? Yes, if uninterrupted and without force. Fourth, by necessity, landlocked property needs access through another land. Fifth, by quasi-necessity, when land is divided, existing usage continues. So law ensures usability even without ownership. Exactly. Law supports functional utility of land. 5. Extinction and suspension. Rights can end. Can easements be removed? Yes. Very important. Extinction conditions. Non-use for 20 years. Destruction of property. Legal termination. So if unused, right disappears. Correct. Rights must be exercised to survive. 6. Licenses, a different concept. Then what is license? Same as easement? No. License is permission. Easement is legal right. License characteristics: personal right, no property interest, generally revocable, not transferable. So license is temporary, easement is stronger? Yes. Easement attaches to land. License attaches to person. 7. Impact on property value, most critical for valuers. Now the real question: how does this affect value? Positive impacts. Right of way increases accessibility. Water rights improves usability. Road access enhances development potential. So easement can increase value? Yes, especially when it improves utility. Negative impacts. Burden on servient land. Examples: public right of way, power lines, drainage rights. So owner cannot fully use land? Correct. Restrictions reduce usability, development potential, market value. 8. Real valuation insight. So same land with and without easement, different value? Absolutely. Easement modifies rights, control, utility. 9. Critical professional understanding. What should a valuer check? Title documents, easement rights recorded, physical inspection, impact on use, identify, beneficial easements, restrictive easements. 10. Final insight. So ownership is not everything. Rights over land also define value? Yes. Value is not just about what you own, but what rights you can exercise and what rights restrict you. That changes everything. Yes. A professional valuer must always see ownership, rights, restrictions, because invisible rights often create visible impact on value.